I don't know about you guys, but I want to take a class with Alexander. How many people want to take a class? Yeah, right? See? Okay. And the nicest thing as a law professor, and I say this with some chagrin, I'm afraid, is that Alexander should get an A+ as a law professor, because I heard more about the law and the Constitution from him than I hear from almost any law professor in most elite law schools, which is a tragedy. So, anyway, A+. Yeah, hear, hear. Thank you. So I'm going to take a different tact. I exhausted, I apologize to you yesterday, all of what I had to say about religious freedom, so I want to go in a different direction and talk about some of the apocalyptic language that we've heard and some of the threats that I think are emerging and why we want to resist them. So I'm going to pick Ted Cruz, just because he's an obvious candidate. And he said, after the marriage decision, "It's my hope that the marriage decision serves as a spark to start a fire that becomes a raging inferno." Now, I have no idea what that means. I actually have no idea what that means. But what it does tell us is that bubbling up with all of us, many, many people across the country, is a deep frustration. And I think in that deep frustration, at least two reactions for me are likely to get traction, and I think are likely to be dangerous to the cause of religious freedom ultimately, and possibly to marriage as an institution itself. So one I touched on yesterday, I'll go back to it for a second. It was what I called the canary in the mine, and this is the marriage and the licensure clerk, because they will be implicated in every state in America. As we said yesterday in a long discussion, many states don't have public accommodation laws right now based on sexual orientation, so some of these collisions won't arise. Some of the ones that Jean described won't ever happen, at least until those public accommodation laws come online. But you will have marriage and licensure clerks implicated in every state in America because the state has the monopoly power over marriage. Now, yesterday I mentioned that offices in Alabama had shut down literally the entire marriage function to everybody. And this apparently also happened in Kentucky, I learned over the night, precipitating lawsuits by the ACLU. Didn't take the ACLU long, did it? Now, I think shutting down these offices entirely is the worst possible way to proceed, as I said yesterday. Maybe made a terrible analogy to Orville Faubus, but basically, at the end of the day, I see this as an apparatus of the state, defying a Supreme Court order that represents the law of the land. By shutting down a function entirely to exclude gays, they're denying it to everyone. And for me, that violates the separation of powers and the rule of law. You might take a different view of that, but I think it's the wrong way to go. Now, we've seen other approaches in the last year. So, for example, North Carolina did something that's clunkier than what Utah did. I think Utah got it right. I'll tell you why again at the minute. But what North Carolina did, in an effort to shield objecting employees from collisions over same-sex marriage, it basically instituted a procedure where magistrates and marriage registrars could recuse themselves for solemnizing or registering a marriage, and that recusal lasts 6 months. Now, this was actually deeply contested. 5 years ago, this would have been uncontroversial, but the goalposts have moved as same-sex marriage has been recognized. I think we had a lot of discussion about that yesterday. But this became law only after overriding the governor's veto in North Carolina, and it was a nail-biter, not in the Senate, but in the House. Now, I think the real problem is that when religious objectors pull down on this accommodation in North Carolina law, they can do it the very first time a gay couple presents. And what that means is that you are going to have a point of service refusal. In other words, a gay couple who is there seeking a license to marry, supposedly the happiest day of our life, are going to be told by somebody, that that person has a moral objection to their marriage. And it's going to feel like a moral objection to them. And not only do I think that that's uncool, that we don't, as taxpayers, receiving a service from the state, need to be told by a government employee of the state what they think about our personal marriages, right? But the other problem is going to be that you have to know that that state office right, or that state is going to have hell to pay, right? We've seen what happened in Indiana. We've seen what happened in Arizona. This is not the right way to go. Now, North Carolina could have avoided that kind of offense to its citizens. And I think it can actually still do this by policy. It could have required that officials recuse themselves ex ante, and before the fact, in writing, in order to staff around the objector so that the objector never actually comes in contact with the public. So why would that be better? That would be better because imagine a couple, Steve and Adam, present at the marriage office, which has 3 officials. Let's call them Faith, Hope, and Charity. And only Faith is going to have a religious objection. Now, I want to tell you, my big project in Utah, the single reason that I spent time here was so that Faith does not get dropped out of the boat, right? Faith gets protected. But in this situation, we do not want Faith at the front desk saying to Steve and Adam, oh my God, let me go get Hope or Charity. Instead, we want Hope or Charity doing the intake. And Faith perfectly, reasonably, legitimately can be doing other functions of the office. For example, in North Carolina, she can issue subpoenas or take affidavits or do any other thing that that office does, but she should not be at the front desk if she has an objection. Now notice that Faith is not receiving a pass from doing her job. She performs other functions of the office, and neither is the office failing to do a service that it owes to its citizens. It does it. It fulfills it with Hope or Charity. Now note what also does not happen, and this will be the threat to religious freedom if it does happen. Steve and Adam are never asked to wait longer. They're never asked to step into another line. They never even know that Faith has a private view about their marriage. So dignitary harms evaporate when we make accommodations invisible to the public. Now, we can't make accommodations invisible to the public in every context, but at least when it is an office of the state, I think it is very important to try to achieve that goal. Now, why do I think that Utah improves even on North Carolina's clunkier approach? Because they did not have the invisibility part that I just described. They just had recusal, step away. And I think Utah improves on that, as I said yesterday, by bypassing the objector entirely, essentially outsourcing that function of solemnization to a willing, authorized celebrant in the community, which could be a judge, a religious official, or other people. So Utah both guaranteed access to marriage to everyone on exactly the same basis, and it avoided dignitary harms to our lesbian and gay neighbors. So that's problem one. There are better and worse ways to deal with that. We've got to resist doing it in awful, clunky ways. Second bigger problem, and apologies here because this is a new paper that I'm writing, which of course means I don't completely understand what I'm saying. But don't fault me for that. It's only been 10 days since the decision, so I haven't had a lot of time. But basically, we have heard a constant refrain. How many people have heard this? Let's take the government out of marriage. How many people have heard that in the last few weeks, right? Even before. Now, I don't know what that means either, actually. I'm not sure the people who have introduced legislation knows what that means, but I'm going to describe some of it to you, and then I'm going to tell you why we should resist it. In essence, let me just tell you where some of the genesis of this was. First Things, which is a Catholic intellectual magazine, actually published a pledge which now has been signed by 656 religious figures to, quote, separate civil marriage from Christian marriage. Now, for them, this seems to mean that they should, quote, no longer serve as agents of the state in marriage, no longer sign government-provided marriage certificates. Instead, they're going to ask their own parishioners to seek civil marriage separately from their church-related vows and blessings. So they are, in essence, taking what in our system has been a single step, that the religious ceremony accomplished the religious marriage and the civil marriage in a single step. That's how intimately bound up they've been in our system since the colonial times, okay? They want to take those two steps and divide them into two. Now, the motivation for the pledge I don't have any problem with, and Cole started us off with it early this morning when he talked about complicity. In essence, these folks do not want to, quote, falsify God's word by participating in civil marriages that they see as being fundamentally redefined. And they believe that to continue to do this, to continue with church practices that intertwine government marriage with civil marriage will implicate the church, they say, in a false definition of marriage. But the basic tension here is that in our system, as I said, religious and civil marriage has always been bound up in this way, a single collapsed step. Now, it's true, you can get the civil marriage part without a religious marriage, right? But you cannot in America, in any state, get a religious marriage without the civil part. On this side, they have to be bound up. Now, that's actually, it's a crime, by the way, in every state in America. And that's actually a good thing, that we collapse religious marriage with civil marriage, because we want religious marriage to have civil effects. Without them, we will have stranded religious adherents in the position of mere cohabitants under the law, which means that they have crappy remedies, right? They're not going to get spousal maintenance. They're not going to have the division of property, that type of thing. And who loses in a scheme like that? It'll be the traditionally vulnerable partner, or especially dependents, women, and children. Now, children will get child support. These women will not have property division. They will not have spousal maintenance available to them. And the children will lose because their mothers, if they have custody, will experience severe financial strain. Ironically, this idea from this Christian source would put these women in the same position as women who are in the Sharia courts in Great Britain right now. Because what has happened in Great Britain is that these women have marriages that are off the grid. In other words, they have a religious marriage and no civil effect. And that means that the Sharia courts are applying religious norms to these women in Great Britain that wildly depart from what civil law in Great Britain would provide, like maintenance, property division, and those types of things. So it's deeply ironic that some people reacting to same-sex marriage are actually trying to move women potentially in this awful, awful place in ways that I think are really unfortunate. Now, you could say, Wilson, whatever, we'll just give some education to these women and they will know to go do the second step. So it's solvable. And we do that in other countries, apparently, although I'm still educating myself about that. I think, though, that that's still fraught with risk, at least in the near term, because there will be weaker earning people who don't know to do that, right? So in the event of divorce or death, right, it's not just divorce, they may be left unprotected by the law, and that would be unfortunate. But notice what the First Things Pledge is trying to do here. It would foist what it sees as a government duty onto the government and have religion withdraw from the world in an important aspect, so kind of become an island. Now, in the 10 days after the decision, we have state legislatures around the country introducing measures also to sever the tie between religious and civil marriage. But they would foist the marriage function away from the government onto religion, ironically going exactly in the opposite direction. So Texas State Representative David Simpson has asked the Texas governor to call a special session to, quote, divorce marriage from government. He says that government has basically redefined it at the federal level, so let's just get out of the marriage business. Now, for him, this would take the shape of changing the law so that clergy members would issue marriage licenses. The state would have nothing to do with it. Other Texas legislators have said that this is a knee-jerk reaction. We see in Michigan, though, Representative Todd Courser, weeks in advance of the same-sex marriage decision, introducing 3 bills. 2 are relevant here. But both of these would fundamentally change the nature of the state to civil marriage. One would permit religious marriage only, ditching civil solemnization entirely. So if you want to be married, you have to be religiously married, that law would say, or that bill would say. I think that's sort of interesting as a problem too, because there'll be people in Michigan, I would assume, that reject religious marriage. So that would cut them out of marriage, and that seems to me a non-starter. The second bill would preserve religious ceremonies but eliminate the state license in favor of a marriage certificate signed by the clergy. So if you had a religious marriage, you just have this certificate. On the civil side, there would be no license and no solemnization, only the actual institution of what he calls common law marriage, which the whole arc of common law marriage in the United States has been to get rid of it. And this guy is bringing it back. And there would be no solemnization function at all. So let me tell you where my problems with this are, and then I'll wind up. Just like 1 minute, okay? So whatever form this unwinding of civil and religious marriage takes, I think we should be loath to embrace it. And for basically lowercase c conservative reasons. I think we cannot predict well what the outcome of this unwinding will be. So civil marriage benefits from religious marriage, I think, in many ways. You can think of civil marriage as having free-rided on religious marriage, in the sense that religious marriage has norms of permanence and fidelity and monogamy and faithfulness and sexual exclusivity, and they get put into our marriage culture as part of civil marriage, okay? And we can't peel one part away, religious marriage, without adjusting or changing the norms with respect to the rest. At least that's my fear. It would be not unlike that pitcher of water. If I tried to pour over that pitcher of water and leave the ice, it's an impossible task, right? And I think norms work that way. In other words, we can't just peel off the one part that we like or don't like and leave the rest. So in my view, this risks a deep cleaving into marriage, into the nature of marriage. And that would be unfortunate because I think, and we know empirically, marriage protects the adults and it protects the children in it, right? But we don't really know why. We don't know if it's the exit rules, i.e., what a hassle it is to divorce and the fact that you have to divide property and all of these things, right? Or if it's those religious norms, right? So the chances that we're able to make this cleave in a way that doesn't do great damage both to religious marriages and civil marriages, I think, are small. And in any event, I'll just say we've played with marriage a lot. And same-sex marriage may not be nearly so important as what we did when we embraced no-fault divorce. And we thought this was a grand project, right? Ronald Reagan signed this into law in California, if you'll remember, all because adults needed to have the freedom to have, new sexual partners and fulfill their lives and move on with themselves and all these great reasons. And at the end of the day, it eroded our marriage culture, and it had lots and lots of repercussions for children that I think we could never have imagined. So we don't want quickly to cleave deeply into marriage as a way to solve and to make ourselves feel better about a great loss on marriage for many people, right? It's a dangerous thing to do, and we should not do it.